Okay, let's jump right into this explainer on the law of agency. Now, I know what you might be thinking. Legal theory, yawn. But trust me, this isn't just dry textbook stuff. This literally dictates how business relationships are formed and enforced in the real world every single day.
So here's a crazy question to kick things off. Can someone else's actions legally bind you to a contract? Well, the stark reality of contract law is yes, absolutely. Another person can actually enter you into a legally binding agreement without your direct permission. Let's look at exactly how the law allows this to happen.
To keep us on track, we're going to hit 6 main areas today. 1. What is an agency? 2. Creation by agreement. 3. Agency by ratification. 4. By operation of law. 5. Agency by estoppel. And 6. Why this all actually matters to you.
All right, Section 1. What is an agency? Let's lay down the fundamentals. We're looking at the Contracts Act 1950 here, specifically Section 135. It says an agent is a person employed to do any act for another or to represent another, who we call the principal, in dealings with third persons. So the really crucial point here is that this creates a three-way, or tripartite, relationship where one person is legally acting on behalf of another.
This flow brilliantly illustrates how it works. The principal grants authority to the agent. The agent then goes out and deals with a third party. But the legal magic happens right there in step 3. The principal and the third party are now legally bound to each other. The agent is essentially the bridge, bringing the principal and the third party together into a solid contract.
Now, there are a couple of basic ground rules. Naturally, the principal has to be 18 or older and of sound mind, according to Section 136. But here's a really interesting twist under Section 138. You don't even need consideration to create this legal bond. Meaning, absolutely no money has to change hands. You can appoint an agent completely for free.
Okay, moving to Section 2, creation by agreement, specifically express or implied agreements.
So an agreement can be express or implied. Express agreements are super straightforward. They're written down or clearly spoken. Think of handing someone a formal power of attorney. But implied agreements, those can totally sneak up on you. They're inferred from your ordinary conduct, your regular habits, or just the circumstances of a situation.
Let's look at a real-world case study from 1964 to show you exactly what I mean. Chan Yin T versus William Jackson Co. In this case, an adult and a minor were registered as partners. And crucially, at a meeting with a supplier, the adult acted like he was the minor's partner and habitually let the minor order goods on his behalf.
Well, the goods were supplied, but guess what? The bill wasn't paid. The court ruled that because the appellant habitually allowed the minor to order those goods, an implied agency existed. The adult held him out as his agent. Therefore, he couldn't just repudiate the contract. The adult was legally bound to pay the bill. So yeah, your habits definitely matter in the eyes of the law.
All right, Section 3, agency by ratification. This is all about accepting a deal after the fact.
What's really fascinating here is how ratification acts kind of like a legal time machine. Say at time 0, an unauthorized act happens. Later, the principal finds out, reviews it, and decides to ratify or confirm the deal. The law actually retrospectively applies that contract all the way back to the original date it was made at time 0. Wild, right?
But hold on, this after-the-fact agency only works if you meet a very strict legal checklist. The agent must have been acting on your behalf, you have to know all the material facts, and you must affirm the act in its entirety. Absolutely no cherry-picking allowed. And, as established in the case of Kellner versus Baxter, the principal must actually have had legal capacity when the original contract was drafted, not just later on when they decide to ratify it. Let's look at a classic case, Bolton Partners versus Lambert from 1889. A managing director accepted an offer without having the actual authority to do so. The defendant then tried to withdraw their offer, but the company went ahead and ratified the manager's acceptance anyway. As you can see in this quote, once the company ratified that unauthorized acceptance, it dated back to the original agreement. The third party was locked in and could no longer withdraw.
Moving right along to Section 4, by operation of law or agency of necessity.
Picture this scenario from 1874. A horse arrives late cross-country by train and there's no owner in sight to collect it. The railway company, feeling like they had absolutely no other choice, stabled the horse overnight at their own expense just to protect it.
They essentially became an agent of necessity for the absent owner.
So, when the owner finally showed up, could the railway claim reimbursement? Yes. The law deemed the railway an agent of necessity because they met 3 strict conditions under Section 142. First, a real emergency existed that justified action to preserve the property. Second, it was literally impossible to contact the principal for instructions. And third, the agent acted in good faith in the principal's best interests. So they were entitled to reimbursement even without a formal contract.
Now for Section 5, Agency by Estoppel, also known as the appearance of authority.
Here's the deal. If you make it look like someone is your agent, if you create that inference of authority, and a third party trusts that appearance and relies on it to their detriment, the law says you are estopped from denying the relationship. Simply put, you can't back out later and say they weren't my agent if your own conduct led someone else to believe they were.
Consider this really fascinating case from 1919, Soanes versus London and Southwestern Railway Company. The railway company gave one of its porters a uniform. One day, while completely off duty, this porter took charge of a passenger's luggage at the station, and unfortunately, the luggage was stolen. Even though that porter had zero actual authority at the time, because he was wearing the company uniform, it created an assumption of authority for the passenger. So the court held the company liable. They were estopped from denying the agency. They were legally held responsible for an off-duty worker's actions, purely because of the appearance they created. Talk about a costly uniform.
Finally, Section 6, why this matters, and specifically, your legal liabilities. As we've seen throughout this explainer, the law has multiple structured ways of holding principals accountable. It could be through a direct written document, a recurring habit, an emergency, accepting a rogue deal after the fact, or simply giving someone a company uniform. The main takeaway here, you definitely don't always need a signed piece of paper to be on the hook for someone else's actions. So, as we wrap up, I really want you to reflect on your own business dealings. Ask yourself, are your actions creating legal liabilities without you even realizing it? Are you accidentally acting as someone's principal today? The law of agency is literally always at play, so you've got to keep a close eye on the authority you are projecting into the world. Thanks so much for joining me for this explainer.